All right. My name is Ide Dijkstal. I'm going to be moderating this session. After this morning's great discussion about what's happening more internally in the UAE, this afternoon's panel is going to look more widely at the UAE's policies in the region and how it affects human rights and the humanitarian situation in places like Yemen. With reports of widespread abuses of human rights and possible war crimes and crimes against humanity being committed, issues of the rule of law and accountability are critical to working towards achieving justice for victims of these policies. This discussion during this panel of how these abuses can be investigated and prosecuted under international law is particularly timely as the US government assesses its relationship with both the Saudi Arabia in the wake of the killing of journalist Jamal Khashoggi, and also with the UAE, and in particular with the decision of whether to continue the US's policies of selling arms to these countries. So first on the panel to discuss these issues is Osama Al-Faki, and he's the Director of Media, Communications, and Advocacy, and the former Director of Research at Watana for Human Rights. He's also currently a practitioner in residence at Columbia Law School Human Rights Institute. The second speaker is Andrea Praso, and she's the Deputy Washington Director at Human Rights Watch, and in this role conducts advocacy before the US government on global human rights issues. Third speaking will be Chris Rogers, who is a Senior Program Officer with the Open Society Foundation, Middle East, North Africa, and Southwest Asia Program. And last is Professor Sean Murphy, who is the Mahant Professor of International Law at the George Washington University Law School and is a member of the UN International Law Commission. So, Osama, if you want to go ahead.
Sure. Thank you so much. And hello, everyone. I'd like to thank the American Society of International Law, No Peace Without Justice, and Yemen Peace Project for organizing this event and for giving me the opportunity to speak. And I'm very glad to be here in spite of the travel ban. Just to give you a background about Muwatana for Human Rights, Muwatana is an independent Yemeni human rights organization. We work in 20 governorates out of 22 governorates in Yemen. We are 70 staff members. Most of the team is in the field documenting violations of international humanitarian law and international human rights law committed by all parties to the conflict in Yemen. We also produce statements and reports based on our investigative research for the human rights violations, and we release these statements and reports for advocacy. In my remarks, I will cover 3 points: the context of the armed conflict in Yemen, the human rights situation in general, and the involvement of the UAE and the GCC, and also some recommendations. So starting with the context of the armed conflict in Yemen, in September 2014, Ansarallah armed group Houthis seized control of Sana'a by force with support of military units loyal to the former President Ali Abdullah Saleh. And in January 2015, the Houthis forced the President Abdurrabbu Mansour Hadi and the former Prime Minister Khalid Mansour Bahah into house arrest. Hadi fled a month later to Aden and then to Riyadh in March 2015. And by that time, the Houthi Saleh forces had already advanced toward Taiz and Aden. In the morning of Thursday, March 2016, the armed conflict in Yemen escalated by the Saudi-led coalition, launching a military campaign that involved a coalition of 9 Arab countries, including the United Arab Emirates, against the Houthi Saleh forces to restore the legitimacy. And even though the coalition claimed that the military operations meant to support Yemenis, actions are louder on the ground. Today we are in 2019, and we have Yemen is fragmented and controlled by different authorities and different armed groups and authorities. Like we have territories under the control of Houthis, and we have territories under the control of Hadi government forces and resistance groups. And also we have territories, in theory, they are under the control of the Yemeni government, but they are, in practice, they are controlled by UAE proxy forces. The human rights situation in general, the fact that has never changed since 2014 and 2015 till now is that all parties to the conflict have committed grave violations of international humanitarian and human rights law. The Houthi armed group has been responsible for arbitrary detention, enforced disappearance, and torture in the territories they control. 12 journalists and 6 members of Baha'i minority are still detained, and one of the detained Baha'i members had been sentenced to death in Sana'a by the Specialized Criminal Court. In addition to the use of landmines, they are also responsible for recruiting children, sending them to front lines to fight, or using them for logistics, to provide logistics in front lines, or to manage the security checkpoints. And also they are responsible for the most bloodiest indiscriminate ground attacks in Taiz, Ma'rib, and Al Jawf by using the indiscriminate weapons like the mortar shells. Moreover, the Houthi armed group is also imposing a blockade on the city of Taiz, which makes the movement of people very difficult and unbearable. On the other hand, the Saudi Emirati-led coalition has shown also no respect to the civilians or to the international law in Yemen. The airstrikes have targeted civilians and civilian objects, including schools, hospitals, markets, weddings, and funerals. And I still remember the funeral attack in Sana'a in October 2016. Once I read the news on the social media, I thought it was a joke. And I couldn't believe it till I heard the sirens of the ambulances in Sana'a when they are moving the bodies and the injured people. And it took me a long time to comprehend the number of victims who were killed and injured in that attack. The coalition also has imposed a blockade on the Yemeni sea and airports. And Sana'a International Airport has been closed since August 2016 for the commercial flights, which made it very difficult for the Yemenis, those who want to travel abroad, or for those who are in need for medical treatment to travel. And I personally know some cases of people who needed medical evacuation, but unfortunately they died because they couldn't get the medical evaluation on time. And some of them died like in Aden Airport or in Seyun Airport before the departure of the flight because they couldn't bear the long hours of travel from Sana'a to these parts of the country. One of the common practices between all parties to the conflict in the north and the south is the arbitrary detention, enforced disappearance, and torture. And in some cases, the torture leads to death. In 2017, Muwatana investigated at least 52 incidents of torture were committed by Hadi government forces and the UAE proxy forces, including 14 incidents where torture led to death. And in 2018, at least 23 incidents of torture committed by Hadi government and the UAE proxy forces. In addition to the rule in the Saudi-led coalition military operations, which has killed and injured civilians since March 2015, the UAE proxy forces are responsible for restricting the movement of Yemenis from the north to the south to the city of Aden. And the travelers who are from the north face abuses, might get detained for hours at checkpoints, and they could be refused also access to Aden. Mainly if they don't have a ticket out of Aden International Airport. So for instance, if I'm traveling from Sana'a to Aden, and my ID shows that I was born in Sana'a, I wouldn't be allowed to go to Aden unless I have a ticket shows that I'm traveling from Aden International Airport. In response to the UN panel of experts report issued in January 2018, the Yemeni government has indicated in a letter dated on March 20, 2018, that these armed groups, the security belt, the Hadrami elite forces, and Chabwani elite forces, were established based on regional and tribal backgrounds and are not under the control of Yemeni military institution. Today, and in 2019, the question, or again, the fact that has never changed, that is the Yemeni civilians are paying the cost of this armed conflict. And it's very important for this war to be ended, but also most importantly is to ensure accountability and reparations and holding those who committed these violations accountable. And the victims also entitled to get an apology and also a compensation, and also finding justice someday. Finally, I would like to emphasize mostly on the following recommendations. The UN Security Council and the UN Special Envoy to Yemen should emphasize on the matter of accountability and emphasize on an end to immunity of all parties to the conflict. And all states must stop their arms deals and arms provide to the conflict parties in Yemen. And finally, the supporting to the GE is essential, but also it's very important to move on from documenting the human rights violations to holding these people who committed these violations accountable. I'll stop here and thank you so much.
Thank you. Not going to bother. Well, I really want to thank Osama, because those of us who do work on Yemen would not be able to do the work that we do without his dedication and that of Muatana. And I think that Muatana's presence, ability to come to the US, thankfully, and presence here has really helped persuade a number of people in Congress to start thinking about Yemen in a different way. So we hope there are more opportunities for you and others to come back. Human Rights Watch has been reporting on the conflict from its outset. We've been reporting on Yemen for many years. We had someone physically living in Yemen, reporting out of Yemen at the time that the war began. And the focus of our reporting has largely been on civilian casualties, largely from airstrikes, although we have reported on a range of other issues, which I'll touch on generally. And I think it's interesting and well-timed that we're talking about the UAE here today, because a lot of our work has been focused on Saudi Arabia. We talk about the Saudi-led coalition, although increasingly I think people talk about the Saudi and Emirati-led coalition. One of the reasons why we talk so much about the Saudi-led coalition is the utter lack of transparency related to all coalition activities, making it hard to identify which government was responsible for which activities. But I think as time has progressed, it's really become clear that it's either not important to identify given how closely they work together, or that the UAE is playing a larger role in a number of other areas than they were at the outset. But nevertheless, the Saudis do take the lead in the airstrikes. So a lot of our reporting has been on the excessive civilian casualties from Saudi-led airstrikes from the inception of the conflict. We've documented hundreds of civilian casualties, either disproportionate attacks on civilian objects such as hospitals, schools, marketplaces. We have not documented the deliberate targeting of civilians per se. Instead, it just seems to be almost an utter disregard by the Saudi-led coalition about distinguishing between civilians and military targets. And this is despite a tremendous amount of support from the US government over the years. So many of you are familiar with the fact that the US finally stopped mid-air refueling of Saudi aircraft. But the US mid-air refueling, although important, is really just a tiny component of the US support for the air war and the coalition in general. It has waxed and waned over the years based in large part on the coalition's acceptance of the US role and influence, but at times there have been US military members inside the operations rooms. They have provided lists of targets. They have provided lists of coordinates that cannot be targeted, which nevertheless were targeted anyway. They've provided training, assistance, and the absence of refueling does not mean that US personnel are not involved in repairing Saudi military aircraft, in maintenance, in selling parts, and so on. The New York Times did a really helpful piece, I think a week or two ago, outlining essentially the US fingerprints over all aspects of the coalition. So I think it's really key to note how integrated US support is for the coalition. Now, again, a lot of the air activity is led by the Saudis, though it's not always clear what role the UAE has played there as well. But following a sort of pattern of civilian harm, the coalition did institute something called the JIAT, the Joint Incidents Assessment Team. This was created by the United States with the coalition, for them. And it was designed to be an investigation team that would look at incidents of civilian harm, violations of the laws of war, and so on. Unfortunately, the JIAT has really utterly failed at its task. It exists. It's constituted of people who have as their remit these investigations. And it does do investigations and create some kind of internal coalition report. But Human Rights Watch has documented extensively the failure of the JIAT to really examine incidents of civilian harm, a total failure to identify responsible parties. So they don't identify which country or which person certainly is responsible for a violation. And we've seen very few cases where there's been any kind of corrective action. So certainly we haven't seen prosecutions. We haven't necessarily documented war crimes that require prosecutions. It's difficult to do that. The JIAT may have, but we have not seen any prosecutions. We have not seen disciplinary action. We haven't seen, but most important, we haven't seen a change in targeting practice. So if they're doing these investigations and concluding that something went wrong, they're not feeding that information back into their targeting process. And in fact, the investigations that we've been able to examine, which they have released, the JIAT has released periodically to the public, usually timed to some sort of international inquiry, whether it's a UN related event or something else. We've examined all of those reports and we've seen very little culpability. So when they don't find any culpability, there's no reason to adjust targeting practices. If they conclude that what they were doing was just fine, regardless of the numbers of dead civilians that we document, that Montana documents and others, there's no reason for them to change their practices. And then the other significant area that we've documented, which Osama mentioned, is abuse in detention. And there is abuse in detention, as Osama said, by all parties. By the Houthis, absolutely. Again, the Post just did some really good reporting on Houthi abuses. I don't think it's surprising to anyone that there is abuse in Houthi detention. It's still very problematic. And the Houthis have a lot of interest in being treated like a state actor. They want and have a seat at the negotiating table now, and they need to be held to account the way any other state actor would be. But in particular, we've also documented, as have others, abuse in UAE detention, whether the detention is by UAE forces themselves or UAE-backed forces or proxy forces working for the UAE. We did extensive documentation of torture in UAE-backed detention. Last year, we released that simultaneously to an Associated Press report that documented similar torture and other ill treatment, including US government involvement, US personnel either in the room or receiving information, knowing that it had been obtained through abusive means. Just last week, The Intercept was able to locate a previously confidential report that the Defense Department submitted to Congress last month in response to a congressional requirement that the Defense Department do so. And DoD was very careful to say that it had no independent, credible information about US forces involved in or having any knowledge of, or UAE forces for that matter, engaged in detainee abuse. There are a couple of significant problems with this finding. The first is that it's just false. It's just clearly not true that detention has not been abusive and it is probably still quite problematic today. But second, quite troubling for Human Rights Watch is this notion that there was no independent, credible information. It may, in fact, be that DoD personnel do not have independent, credible information based on their own eyewitness accounts. I would be surprised if that's true, but I'm not in a position to say whether it is or not. But it may be true. However, Human Rights Watch extensively documented this abuse. The Associated Press extensively documented this abuse, and others have as well. So we're in a position now where the US government, the Defense Department, is saying that credible, independent reporting by non-governmental organizations is not deemed credible for the Defense Department. That's very serious, and that's a situation that goes far beyond the issue of whether UAE forces have been abusing detainees. It's not surprising in this administration. It's somewhat consistent with other actions we've seen. but it is quite troubling. And the sort of counterpoint is that the State Department publishes annual human rights reports on countries around the world, and they rely extensively on reporting from Human Rights Watch, from Amnesty International, from local NGOs around the world. They don't ordinarily cite our work extensively, but we form the basis of that reporting, and in particular, local human rights organizations form the basis of credible reporting on human rights abuses around the world. And it's quite troubling if the US government no longer considers that sort of local on-the-ground reporting to be credible. It's also very convenient, of course, because if someone can simply close their eyes and say that they didn't see something happen, therefore it didn't happen, is deeply problematic. That brings me to my final point, because I do want to wrap up and leave time for questions, which is the congressional response. In some ways, a response like that from DoD is actually quite good. If DoD had said, and I don't know why they didn't, we're terribly sorry, it appears that some detainees were abused. That goes against DoD policy. Obviously, we have reminded all of our partners that's unacceptable and we wouldn't ever use such information. Carry on, business as usual. I think that would have been a blip. I don't think that Congress will take lying down this sort of statement from DoD, particularly in the broader context right now, which is that for whatever reason or reasons, and there are many theories, the killing and dismemberment of Jamal Khashoggi really flipped for many, many members of Congress their understanding both of the Saudi regime and of the region more generally. It has prompted members of Congress to re-examine some of their long-held beliefs, many of which come from extensive and expensive lobbying on behalf of the Saudis and particularly the UAE. I think people are very familiar with the significant lobbying apparatus that the UAE employs here in Washington and elsewhere. And I think that the killing of Jamal really forced members to be more critical about the information that they're receiving. Last week, I was at a memorial for Jamal Khashoggi. It was 100 days since he disappeared. It was held in the Capitol, and I have never seen more members of Congress show up to an event than that. Members left the room because it was clear they wouldn't have a chance to speak because there were so many ahead of them who were prepared to speak. Both chambers, both sides of the aisle. So it was really remarkable. And the challenge for advocates like myself now is how do we capitalize on that energy? How do we remind people that Jamal, although a special person who needs to be remembered and whose killing must be condemned, is but one person. And there are millions of Yemenis suffering every day, both the direct impacts of war as well as, I think we probably aren't going to have a chance to talk about starvation and famine much, but as well as in addition to the sort of health and famine implications of the conduct, we've now started to see food being used as a weapon of war. So sort of exponential issues. So as I said, the challenge for those of us in Washington who work on these issues is channeling that energy, having members of Congress really pay attention to what's happening more broadly in Yemen and what these regional actors like the Saudis, like the Emiratis are doing, not just in Yemen, but in the region and around the world. Thank you.
Great. Excuse me. Thanks very much. Just by way of introduction, I work with the Open Society Foundations, which is a large global human rights philanthropy. We've been providing funding and advocacy support to a number of US, European, and Yemeni civil society organizations for the past several years now, with a focus on a couple different fronts, but principally on supporting advocacy at the United States and in the United States at the international level, as well as in Europe. Very much focused on trying to work with many partners here on improving compliance with IHL, protection of civilians, and promoting accountability more broadly. I guess I would also underscore what Andrea said, and very grateful to be here with Osama. Mindful of the fact that we're on a panel about Yemen in many ways, and it's very difficult for Yemenis to often speak in these kinds of fora, and so really grateful both for the work that Osama and Watana has done, but as well as for his presence here and being able to speak and represent those views, and for I think a lot of the partners, again, many of whom are here, who helped to get Osama around the visa ban and to be able to be present here. So turning to the question a little more specifically on accountability, I guess there's maybe two questions I'd like to kind of pose and maybe walk through a little bit, at least in terms of some of the thinking that we at Open Society and some of our partners are grappling with. So the first is what is the vision of accountability in and for Yemen? I pose that mindful of the fact that, you know, we talk a lot about accountability. That word is used and invoked a lot. And I think, yes, at a formal and abstracted principled level, I think we all have a shared understanding of what that means. But I do think it's worth pressing a little bit in the context of Yemen, especially as we look out maybe more towards a medium and longer term. What is and how do we, and I'll come to that in a second, articulate a realistic vision of what accountability could practically mean in this context? And secondly, to that point of we, again, a word that I think is invoked and used a lot. And I guess I would not problematize that, but ask that we unpack it a little bit. And who is the we that decides what accountability could and should look like in and for Yemen? I think one of the things that at Open Society we're very attentive to is trying to make sure and work with partners to ensure that the questions around accountability and those issues really are driven by Yemenis and Yemeni views and voices. Again, that's not unproblematic, obviously, in this context. But I think if you take a step back from the current conflict as well as its historical context, it's very clear that Yemenis have had very little say in what happens in Yemen. And so I think when it comes to the question of accountability, we likewise, I think, have an obligation to interrogate that and think about what are the ways in which Yemeni views are the ones that are driving the conversation. And coming back to the question of a vision of accountability, and again, with that caveat, as I just described, I wouldn't pretend to lay out what that may look like, nor would our organizations. But I think it's worth trying to spend some more energy to provide perhaps some infrastructure and thinking around, again, what a medium and long-term possibilities could look like. It's being very mindful of the fact there's, of course, a lot of political uncertainties at the moment, a lot of uncertainties and dynamics militarily on the ground. So what we're really asking here are questions that are very difficult to game out. But I do think that there are, it's worth, again, trying to think a little bit over the horizon and think about ways in which we as a community, a legal community, and human rights organizations and others who are concerned can try to have a more detailed and more thoughtful conversation about what kind of steps accountability could meaningfully take. So as was referenced earlier, the GEE was obviously a major step in that direction. A very welcome one, obviously one for a variety of reasons that's very constrained, but one in which I think many of our organizations are not only hopeful for, but really trying to support and make sure it can have an immediate impact. But just, I think that one question, I think to begin that conversation could be what happens after the GEE? And I don't mean only in terms of the extension of its current mandate, which is a fight to have and a fight to fight, but also, would we see the GEE as somehow expanding its mandate over time? What would it mean to better resource the GEE? Would the IIIM in Syria be a model for a stepped up international mechanism? What does that lead to down the line, particularly in the context of ongoing political negotiations? Again, I think that those are questions sort of worth asking and putting some new ideas and thinking on the table. And likewise, again, mindful of the fact that many of those are conversations that Yemenis really need to be at the fore of. I think that those in the broader human rights, legal community, international legal practitioner communities can perhaps play an even more active role in what that could look like. I think that, many of us and our organizations and many experts and networks that we're connected to have deep experience in many other countries and contexts that are struggling with transitional justice questions, have thought through the pros and cons of different types of international mechanisms that imperfectly try to deliver accountability and justice. And so I think that, another kind of front on the way forward here, I would suggest, is to really try to create a more robust discussion about how we distill those lessons from other contexts and try to work with Yemeni human rights organizations to think about how those lessons could be applied to a very complex context within which they're operating. And again, really think at a political level what that would mean to try to build a strategy or vision that may take several years or many years to realize, but to be a little bit more proactive and deliberate about that. And again, to do that in a much more cooperative way. And there's a number of benefits from thinking about things in that lens. Firstly, is that as we all know, the conflict is going on, the question of accountability will be subject to political realities and negotiations. And I think we really can't be blind to that. There was some comments in the last panel, which I think were, about how there are certain, ideas or lines or issues here that are non-negotiable. And I guess, not to be flippant about it, it strikes me that actually these things are negotiable. These are things that can be negotiated away or thrown away. And very often accountability and transitional justice are the kinds of things that are very quickly negotiated away or not negotiated about at all because they're left out of the room. And so, I think one of the benefits of articulating a more positive, constructive vision of what accountability could look like helps strengthen the negotiating position of organizations, Yemeni and international alike, who would like accountability to be on the agenda in the political negotiations, and to think very practically about what kind of proposals could allow accountability to have the strongest possible prospects of exercising influence within the context of those negotiations. Secondly, and this relates to the kind of who decides, I think that trying to put some proposals like this on the table really would help put Yemenis again in the driver's seat, and particularly those Yemeni groups that really see accountability and justice as not only something that they're focused on, but I think as we heard earlier and we're all familiar with, we believe is inherent in having a sustainable peace. So again, I think there's real political value, strategic value in moving in that direction and helping empower Yemeni groups to have a greater say in the context of those political negotiations. And relatedly, I think especially when it comes to understanding what kinds of ideas to be putting on the table when it comes to accountability, again, at a very practical level, there are questions that at international level, but there are also very real questions that will exist at a national level of what national accountability, but also local reconciliation and accountability will look like over time. And those are the kinds of questions that Yemeni, local groups, activists, human rights groups who have long experience within the country and at multiple levels are absolutely in the best place and position to be able to navigate and think about. And just, there are many obvious examples of why that's true. But just two examples or illustrations that pop out in my mind and in this context of this discussion is, firstly, the UAE, which, exercises pretty significant territorial control over large swaths of southern Yemen. It's backing a large number of security forces, as Osama mentioned, like the Hadramati and security-built forces and a range of other militias. Its relationships with tribal sheikhs and other brokers is incredibly complicated and backed by huge amounts of financing and weapons and arms. The relationship between the UAE and Islah and other parties is a very complicated one, which will have huge ramifications for the political future, both of the country and especially in the South. And the way in which accountability has to take account, of all of those political considerations is something that I think Yemeni organizations, Yemeni activists like Muatta and others are really in the best place to help think through, and most likely with the help of other international organizations and experts with broader experience. But that local knowledge, I think, is absolutely essential. And another example, there was a great report, maybe last month or so, by the Sanaa Center looking at the kind of mapping the war economy. And I think it's another reminder of another set of actors and elites here who are involved and complicit both in the war and violations. And the way in which economic power, especially amongst certain elites within Yemen, will likely have a huge influence over what post-conflict Yemen looks like. And again, it's another area in which is both politically and strategically true, but also something that, again, many Yemeni actors on the ground will have the best understanding of how to navigate. And I guess I would also say the intersection of corruption and a lot of violations and transitional justice is one in which I think is a ripe one for building popular legitimacy within the country for transitional justice and accountability going forward. I think both Yemen's own history in terms of its revolution and reaction to kleptocracy and deep corruption, as well as that's obviously a much broader grievance throughout the region, everywhere. But I think that could be interesting fertile ground to explore, especially as one tries to think about how you build popular long-term legitimacy for a really meaningful accountability process. Yeah, I'll leave it there. So thank you very much, and looking forward to questions.
Just before you speak, I should have mentioned that Professor Murphy is also the president of ASIL. So just wanted to recognize that as well.
Well, thanks, Heidi. Yes, I was going to thank the Society for hosting the event, but then I thought, I'm thanking myself in some respect. But my thanks as well to the No Peace Without Justice Project and the Yemen Peace Project for partnering to bring this about. I think it's a wonderful opportunity to have an important conversation. I do want to start by noting that I'm not an expert in Yemen. I'm not an expert in the UAE. Indeed, I don't hold myself out as an expert in the Middle East. So you may be wondering, why is Murphy up there on the panel? And I suppose the answer is that the organizers thought it might be helpful to have someone on the panel coming at this from the broader perspective of international law, and talking a bit about some of the issues that are relevant, I think, in attempting to resolve some of the problems that have been discussed. And I thought I would do this mostly from my perspective of being a member of the International Law Commission, which, as many of you may know, is a body of the UN General Assembly. Some view it as the UN's legal think tank. It meets every summer in Geneva, and it generates various projects, some of which become treaties, like the Rome Statute of the International Criminal Court. But even if they don't become a treaty, they are restatements, black letter rules in different areas of international law with very detailed commentary associated with those rules. And so they often are projects that people will grab a hold of to try to talk about the way international law plays into problems, including the ones that we're talking about here today. So I thought I would just briefly, in my time, say a couple words about 5 International Law Commission projects that I think are worth bearing in mind in this context. And I'll start with the more abstract and move to the more concrete. At the very abstract level, the Commission completed a project in 2006, which we call the Fragmentation Report. The idea in the report was to think about, how do you handle the fact that there are different subject matter areas of international law which do not necessarily talk to each other. In this particular context, the most obvious example of this would be the realm of human rights and the realm of international humanitarian law, which have their own sets of treaties, their own sets of institutional mechanisms, and so on. And although they operate in harmony in many respects, in some situations they clash, typically with the realm of international humanitarian law being somewhat less protective of individuals than the realm of human rights law, as a nod to the ability of states to engage in uses of force for military purposes. So the Fragmentation Report was an effort to try to ask questions about, how does one reconcile potentially conflicting areas of international law, doctrines like the later in time rule superseding the earlier in time rule, or the lex specialis taking precedence over the lex generalis. The report talked about the concept of jus cogens, peremptory norms of international law from which there can be no derogation, things of that sort. So again, at a relatively abstract level, particularly if you're an international lawyer, that's not a bad report to look at, depending on the issues that you may be confronted with. The second project is, in some respects, an offshoot of that. This was a project the Commission completed in 2011, and it was on the effects of armed conflicts on treaties. Effect of armed conflicts on treaties. The idea in the project being, when a conflict breaks out between two different states, in what circumstances do relevant treaties continue to be enforced, and in what circumstances do they basically disappear or become suspended? So an obvious example would be two states in a belligerency with each other. You would not expect them to comply with a trade agreement, right? Where they would continue to send goods and services back and forth. You would expect that type of an agreement to be suspended. By contrast, you would not expect a human rights treaty to be suspended, right? So this project, again, completed in 2011, Effects of Armed Conflicts on Treaties, talked about how should we approach the continued existence or the disappearance of treaties when an armed conflict breaks out. There's an interesting annex to the project where there's an indicative list of treaties that remain in force, and that does include treaties on protection of human rights. It does include treaties on international criminal justice, and it does include treaties on settlement of disputes. So that's just an example of, a place to go to think through this, because I think to some extent we're too quick to grab a hold of any old treaty and say this is relevant, when you have to stop and pause and ask, does it continue to operate in this particular context? Third project is that in 2014, the Commission completed work on the topic expulsion of aliens. Expulsion of aliens. And so this was a look at, when is it appropriate, when is it lawful, and when is it unlawful for states to expel aliens. And in Article 3 of this project, there's a sort of generalized recognition of a right to expel an alien, that if they are not of your nationality, you can generally expel. But then pretty much the entire rest of the project is indicating circumstances where you cannot do that. So you can only do it in accordance with the law. That law has to be transparent, has to be applied by an independent decision maker. You cannot expel refugees in violation of refugee law. You cannot expel stateless persons. You cannot expel persons that would make them stateless. You can't deprive persons of nationality for the purposes of expulsion. There's a prohibition on collective expulsion, which indicates, this is Article 9, that you have to make an individualized assessment with respect to persons and not do it as a group. A prohibition on disguised expulsion, taking measures that have the effect of expulsion, even if you don't call it as such. And then the project also, I won't go through it all, but talks about the rights of the aliens who are being expelled, non-discrimination, protection of vulnerable persons, protections required both in the expelling state and in the state of destination, and then also certain procedural rules that have to be applied in terms of allowing the person to contest the expulsion and so on. The fourth project is a project we completed in 2016 on protection of persons in the event of disasters, with disasters defined as either natural disasters, tsunami hits Philippines, or man-made disasters, which can include an armed conflict or some circumstances where there's a calamity causing great human suffering and distress, mass displacement, or large-scale material or environmental damage. And so this project is attempting to talk about rights and obligations of states to cooperate when a disaster occurs. And it talks a bit about the role of the affected state in acknowledging that there's disastrous situations that need to be addressed, the duty of other states to extend assistance to the affected state, the way in which those offers of assistance must be considered, including in Article 13 an interesting provision that says consent to external assistance shall not be held arbitrarily. And I note that this would apply with respect to not just a state where the disaster occurs, but an entity that occupies a part of a state and is unable or unwilling to provide assistance to the people also to receive this assistance, and talks about ways in which that external assistance might be facilitated and so on. The last project I'll mention is one particularly close to my own heart because I'm the Commission's special rapporteur for this project, and this is our project on crimes against humanity. So the Commission embarked about 4 years ago on an effort to draft what we hope will be a convention, a new convention on the prevention and punishment of crimes against humanity. We've done a full first draft. We've got a preamble. We've got 15 draft articles. We've got an annex. We've just received in comments from governments and international organizations and NGOs, which we will next summer use to finalize this project. But next fall of this year, 2019, we will send the final draft to the General Assembly and hope that they transform it into a treaty. So what would this do? It defines crimes against humanity, drawing largely on the Rome Statute definition in Article 7. It has provisions on prevention. So before the crimes occur, what should states be doing to try to make sure they don't happen? And then it has a series of provisions about criminalization within national law of crimes against humanity that talks about the different modes, the committing the crime, the assisting or facilitating of the crime, talks about command responsibility, talks about no superior orders defense, things of that sort. Maybe the most interesting part of this would be that it has an autidere aut judicare provision, so that if an alleged offender turns up in your territory, you are obligated as a party to this convention to submit the matter to prosecution unless you extradite or surrender to an international criminal tribunals. So it's sort of a no refuge provision of the kind that exists in many treaties. If you're familiar with the Torture Convention or the Enforced Disappearances Convention, this is what this treaty would do as well. Finally, it would have provisions on protection of victims and witnesses and others, and also some provisions on mutual legal assistance to try to assist in the process. So we'll see if that becomes a convention. If it does, that will be of some significance for this general area. Last thing I'll say before finishing is, and this is separate from the International Law Commission, I have done a fair amount of work on reparations. And given that our panel in part is to deal with reparations, I think I should say something about that. Obviously, one wants to address crises as they're happening and prevention and perhaps criminal punishment and so on. But ultimately, reparations is an extraordinarily important part of the story of addressing any widespread crisis. And let me just say three things. The first is, I'm currently involved in a case at the International Court of Justice where one country is litigating against another country to deal with reparations relating to a multi-year armed conflict. This is the DRC versus Uganda case. This is a case that's lasted now 15, 16, 18 years. and we're just now getting to the reparations phase, and we'll see where that goes. It's going to take further time for the court to issue its decision. We'll see what the decision says, and so on. My point being that litigating this out, if you can find a forum, is not necessarily the best way to be thinking about reparations. It's time consuming and it's unclear where it will end. Second possibility would be to have some sort of commission, a claims commission of some sort. One of the more recent ones of this kind was the Ethiopia-Eritrea Claims Commission that existed from 2001 to 2009. That was a fairly robust process. It moved along fairly quickly. It dealt with a wide range of claims, including harms to civilians and so on. But again, at the end of the day, although the story was told, and if that's an important part of the reparation process, then that's fine. But at the end of the day, no money was actually paid by either country to the other. So at least in the context of compensation, you might not point to that as a success story. Third thought is, perhaps the best way to think about reparations in a context like we're talking about is something more in the nature of like a Marshall Plan or something, meaning that you approach the matter as, when we get to that point of the end of this crisis, is it possible to persuade all the actors involved that it's in everyone's interest to rebuild a society, to rebuild its institutional structures, its health clinics, its hospitals, its everything. Perhaps there would be money available for something along those lines. This would be less a process of pointing fingers and more a process of trying to say, let's try to get to a place where collectively we can help rebuild a system that's suffered dearly.
Well, thank you. We're going to open it up to questions now. I think we'll take maybe a couple questions at a time. Is it possible? I might pass the mic around so that. So, are there any questions at all? Anyone at all?
Hi, my name is Caroline Tynan. I'm currently finishing up my PhD on Saudi foreign policy post-Arab Spring, and this question's for Osama Al-Faki. Or actually, I guess it could go to anybody, maybe Andrea Passell as well. But I was just wondering to what degree you might be able to say whether the more the UAE has gotten involved in this conflict, if that, to what degree that has changed, made the conflict worse, or if it was just already from the very start with the Saudi role in leading the intervention, a complete really failure when it comes to, taking into account ordinary lives of Yemenis.
Are there any other questions? Oh, yeah.
Hi, my name is Pascal Bachter from POMED. My question is mainly for Osama, but I guess anyone can answer. To reiterate what Andrea said, I don't think we can get much information if it was not for the people on the ground. So first off, thank you so much for that. My question to you is, if there's one demand that you, as a person on the ground, as an organization on the ground, if there's one demand that you can make from Congress, I know this is a tough one, but what would it be?
Regarding the first question, I think the armed conflict is bad from the very beginning. When it started in September 2014 and when it got escalated in March 2015, And the problem with the armed conflict that as long as it's ongoing, it gets more complicated, and there are many different groups or parties appear here and there, which make it very much complicated to be solved. So the sooner the better for the armed conflict to end. Regarding the demand, I mean, I have many. I don't know from where to start exactly, but I think to stop the fueling the armed conflict with the arms sales and with the logistics support, and also to push and to emphasize on the accountability on Yemen, this would be my demand. And if the list is open, I have many other demands to include.
Just on the UAE point, I think that the challenge is that the Saudis and the Emiratis are involved for different reasons. The Emiratis are also better at not killing the wrong people. They have a more professional military. They're also apparently very good at torturing people in detention. So I don't think that there's been a material worsening of the conflict, but I do think that as the Emiratis gained territory, their regional interests were sort of, they were getting some of what they wanted, and they have a very entrenched desire to stay where they are. I can't really speak to the complex political situation, but I do think that having an overwhelming entrenched view about retaining territory does make it hard to engage in discussions about potentially giving up some of that territory. But in terms of the actual severity of the conflict, I don't know that anyone has documented that.
Maybe the only thing I would add to that, I mean, just underscoring the fact that, and the point that there's sort of some divergence of interest between the Saudis and Emiratis, which has also evolved over time, in particular as the Emiratis have changed the nature of their military involvement. But I guess maybe just piggybacking on that, I think when one looks out from now, the fragmentation that Emirati involvement has created and to a degree accelerated because of the nature of its presence and its backing of various forces, I think makes putting the country, so to speak, politically or territorially back together again, a much more complicated endeavor. And so I think that, whether that has resulted in worse or more acute levels of human rights violations, perhaps, I'm not sure, but I do think that when it comes to the challenge of achieving, again, kind of accountability in a post-conflict scenario, I think that those facts certainly complicate that greatly.
Other questions, please.
This is a question for Professor Murphy and any other members of the panel that would be interested. I think the International Law Commission is beginning to work on use Kogans as a project, and I wonder how that is likely to interact with the various laws that deal with armed conflict situations.
So we did begin a project on use Kogans about 2 years ago, and the special rapporteur is our South African member, Dira Talati. The project is trying to capture, in the first instance, what do we mean by use Kogans, peremptory norm of international law? Where does that come from exactly? And it's a tricky thing because on the one hand, the way the International Court of Justice has approached use Kogans is in some sense to look at a lot of the same factors that you would for determining any rule of customary international law, that is looking for widespread practice and penio juris, but then also looking to see, do states believe it is not just customary international law, but a peremptory norm? That makes some sense. On the other hand, there's a certain amount of thinking out there that really it's got a closer connection to just deep-seated senses of morality and justice and so on, such that it's, we know that the prohibition on genocide is a use Kogans norm because we just know it. we know that's really bad. We don't have to, look around the world and try to figure out, is there state practice on it? So that's a curious, initial aspect of the project. Beyond that, it's right now in the phase it's in, looking at the way it operates in the context of the law of treaties, Vienna Convention, elaborating a little bit on that and drilling in. But then it's also going through other sources of international law, custom, general principles, and so on. Ultimately asking the question, can international organizations violate use Kogans? And I think the answer will be no, they can't. But that, too, is an interesting issue, particularly when you think about Security Council resolutions or resolutions of regional organizations and so on. A final interesting aspect of it is whether there will be some kind of list of use Kogan's norms. Even if it's illustrative in nature, there would be interesting questions about what norms get on that list and which ones are left off. And whatever's left off, there will be some group out there saying, why isn't that norm on the list? So I'm not quite sure what the commission will end up doing with that. But at the end of the day, to get to your question, Don, I think that the upshot of it would be any rule of international law embedded in a treaty or otherwise that somehow comes up against a use Kogan's norm loses out as against that rule. So if there was some sort of treaty, whether it's in the law of war area or anything else that could be said to conflict with the use Kogan's norms, then it loses. I think what is still difficult about that is that there are claims that extend beyond just conflict with the norm itself. So when we say there's a use Kogan's norm prohibiting genocide, that means you can't, in a treaty, let's say, agree to commit genocide. Fair enough. But does it also mean that a person cannot have immunity from a allegation that they committed genocide before, let's say, a national court? That's a different question. And it's not obvious that that immunity directly conflicts with the use Kogan's rule. The use Kogan's rule is saying, don't commit genocide. It's not saying, and there must be national courts that can have claims against a person alleged to have committed genocide. Things like that, I think, are where a lot of the questions are. And I don't know if the commission will actually reach some of those issues because they're rather difficult. No.
Other questions? Anyone else? So I have a question as well. I wonder if it could maybe be discussed a little bit more about what mechanisms there might be under international law that victims in places like Yemen could utilize now to try to achieve kind of accountability or reparations.
That's a good question. Well, to begin with, the JIAT has the capacity to analyze activities, conclude that they're unlawful, and provide redress. Osama might be able to say more, but as we understand it, there may have been cases of compensation to some people. And that may not be public for very good reasons, or it may not be public for very bad reasons. I don't know. Certainly, there's no systematic process. And our own analysis of the JIAT suggests that even if they provided some form of redress in every instance in which they find some degree of culpability, that's a tiny handful of cases. It's not at all related to the scope of the harm. So that is a mechanism that exists and could be used if it were used robustly. In terms of the international level, one of the challenges, of course, is that the country is in the midst of an armed conflict and a famine or near famine and many, many crises at the same time. So the capacity to administer any sort of claims process is a problem. But moreover, I don't think that the actors causing the harm think that they have any obligation to provide any sort of redress, which is part of the problem. I don't think that if you asked anyone in the Saudi Air Force, they would say that they should try to kill civilians. But I don't think they think there's really a problem with the fact that they keep killing civilians. So you have a sort of a cultural problem. I think the torture is another example. When I was in law school before 9/11, we used to say that the prohibition on torture was a jus cogens norm. Arguably, it still is, yet if one is to look at state practice, it's quite troubling to see how many states do engage in torture. On the bright side, most of them think it's wrong legally, even if they do it. And I always tell people that the one bright spot of the Bush administration's torture program is that Bush insisted that the US government was not torturing people. Not that the conduct wasn't taking place, but that it wasn't torture, because he knew that it wasn't okay, at least then, for a US president to say that it's okay to torture people. Very minor bright spot, but we take what we can get in this context. But again, I think with torture, I think people engaging in it, the commanders who authorize it or look the other way, all think like it's okay, but they wouldn't go to the UN and say, we have the legal right to torture people in custody, which means that when we are at a point where there really are more robust mechanisms to provide some kind of redress, perhaps they have some space. I just want to make one point about the broader accountability issue that I was thinking of as Chris was talking, which is some people would argue that a major factor that led to the current conflict in Yemen is the immunity that was granted to Saleh in the previous conflict. Obviously, it's a very complex conflict, but I think it's a really important cautionary note when thinking about ways to move forward. The people and states argued that the political exigencies of the circumstances required immunity for Saleh in order to move forward. I haven't asked those same people what they think now about how that played out, but I think many, many people think that's sort of the bad apple that started off where we are now. So it's really important to think about that moving forward with respect to this conflict.
Do you want to jump into someone? Just two quick thoughts, I guess. Just to, I think, underscore Andrew's point on the Jayats and the avenue of that providing an avenue for potential compensation for civilians. I think that there should be more attention to that. I think that political pressure can be brought to bear on that point as well, which I think would also have the benefit of pointing out or highlighting a lot of the failures of the Jayat and the failure of the Saudi military to respond to the problems that the Jayat, when it has looked at problematic tactics and policies within the Saudi campaign. But I think that also, and many of us are familiar with this area of work as well, that the precedent that the US and other countries have set in places like Afghanistan, Iraq, and their own operations of providing compensation to civilians is a good one to rely upon to press the Jayat and the Saudis even further to go in that direction and to try to ease that way. Maybe just linking this question to the point made earlier about the notion of a Marshall Plan or a claims commission, which is an interesting one, but and I don't want to delve too much into that, but I think the question more broadly of, when the war comes to some negotiated end, there will be questions of how the country is rebuilt. And there will likely be a lot of money put on the table by the Saudis and the Emiratis to do that. And so there will be, I think, a range of questions around how those who would like to see that result in some mode of accountability or some type of maybe claims commission for victims of the war, and what would be politically possible and palatable. And I think that, finding ways, it's an interesting question to me. I think it would be an interesting question to explore, what different models or imagined possibilities there could be to integrate accountability mechanisms within a broader post-conflict reconstruction plan, and also one that has political legitimacy and the involvement of, I would say, more neutral actors such as the UN or others, because more than likely any Saudi reconstruction or post-conflict reconstruction would be seen as very partisan and not really, unless it was through the right mechanisms and institutions, be seen as I guess, kind of in the interest of justice and accountability, unless Riyadh changed its tune on that. So anyways, but I think that that's an interesting, an interesting example of where I think some different creative thinking could be had, in anticipation of a reality that is very likely to unfold, either in the near or the medium term.
Regarding the jihad, according to my best knowledge, that they haven't compensated people in the incidents that they claimed. Like the one took place in Al-Makha in 2015. We were in touch with the victims and relatives of victims, and they confirmed to us that they were contacted at some point with the jihad, but there is no any compensation or any redresses given to them. And I want also to second the Andrea's point of view regarding the immunity and protection given to former President Saleh, which I believe that it was the beginning of what we have now at the moment, because it signaled wrong message to the people and the authorities or the armed groups that they can do whatever they want and they can go away with it without being held accountable or responsible for their actions and their abuses.
Might just build a little bit on Chris's last comment, which is that if we did get to a place where the conflict's over and there's some money available and a will to go forward with a reconstruction approach, we do have some extensive precedents now, particularly since the end of the Cold War, that might be very helpful in that regard. So immediately people might think about the UN Compensation Commission that was set up after Iraq's invasion of Kuwait, where over the period of about 15 years, experts, mostly sitting in Geneva, seriatim, went through claims that have been submitted by individuals that was in a very rough justice approach. You know, you would submit relatively minimal evidence that you were in the country in the time frame at issue, you were forced to flee your home, or you lost a loved one or something like that, and some form of payment in the nature of $5,000 or $10,000 would be issued to you. And those panels of commissioners went through different types of harms, including environmental harm, to help bring about payment of what ultimately was billions of dollars. So that's one type of precedent. There's also a whole series of them in the Balkans, including something like the Bosnian Real Property Claims Commission, which received claims by individuals who had been pushed out of their homes and someone else had come in and taken over the property. And so a sorting through of who was entitled to that particular property. But there's been the same thing in Kosovo and in other places as well. And then the last thing I'll mention is the Holocaust era programs that were run. Again, you had to have a willing country, Germany or Switzerland or Austria. You had to have willing other actors, the German banks, the German insurance companies, Swiss, and so on. But stepping up and saying, okay, we get that there's an issue here. We will put a very substantial amount of money into a fund, and we will convene a series of experts who will receive an information and then allow for a payout. So I think the good news would be that there's a fair amount of precedence in play, and I do think creative thinking could be brought to bear, assuming you had the predicate will at issue, which may or may not exist. Yeah.
So this question basically comes up from the comments of the panelists in relation to justice, accountability, and reparations. So on the one hand, when it comes to IHL violations and conduct of hostilities, at least we have that system of the J-Act. In some cases, the coalition, despite the initial denials, then goes back and acknowledges some incidents, but the issue of reparations still remains, or compensation remains problematic, but at least they acknowledge some incidents, their the violation. When it comes to the detention or the torture and the enforced disappearance, as Andrea may well know from the advocacy efforts of both HRW and Amnesty and other organizations, what you end up having is flat out denial by the UAE of any involvement in the detention file or running these prisons. And it becomes very problematic when you then sit at meetings and people say, well, then how do you engage that party if the starting point is this absolute insistence to deny, despite the volume of documentation there is by human rights organizations or the media on that front. And Andreas brought up the Pentagon report, ignoring that documentation for that matter. So then if the party, there's enough documentation, it's a very legal question, right? If there's enough documentation of their involvement in the violation, it's not yielding the result, whether with political pressure or even chance to pursue it legally. What then needs to be done on the documentation level to ensure in the future some level of accountability for that particular belligerent party? Are we then meant to try to pursue very specific chain of command to ensure in the long term some sort of individual criminal responsibility for UAE generals, or what is the next step if our constant documentation of their involvement is being met by denial? If the documentation of the facility isn't enough, what should our next step be?
Hi, Ellie Picard, Yemen Peace Project. Building on Rawia's question, are there any mechanisms in the international law ecosystem, and I guess this is mainly a question for Professor Murphy, that can support efforts at documentation and verification, keeping in mind that the GEE's capacity is limited like any other institution? So are there any mechanisms related to the ICC or anything else that can proactively support efforts to document and verify violations of human rights in IHL? And another question for Osama, building on something that Chris said earlier, we know that the National Dialogue Conference after the revolution tried to take up transitional justice in a useful way, didn't really get there. What are there sort of views or changes in the views of Yemeni civil society right now in how transitional justice issues should play into the puzzle of reconstruction and rebuilding and the peace process itself? Have those views sort of changed since 2014? Yeah.
I'll take a first crack at it if you wish. The first question, which was thinking a bit about documenting the chain of command, if you will, or I think we probably need to clarify what it is one might be trying to do in any given context. And I might break this out into three different possibilities. One possibility is you're interested in criminal liability of an individual, of the kind that might involve a prosecution at an international tribunal, like the International Criminal Court in The Hague, or you're interested in a criminal prosecution in a national legal system, which is also possible if there's jurisdiction and so on. And the rules on proving that criminal liability will be subject to whatever venue it is you're before. And that standard will be relatively high because it's a criminal proceeding. But depending where you are, there may well be rules about something like command responsibility, which could occur either in the context of military leaders or civilian leaders, and typically speaks to both the issue of that person commanding or controlling others and asking them to go off and do bad things, which they will now be liable for themselves, or not asking them to do it, but they then do it and the commander fails to punish them for it or discipline them for it. That too violates their command responsibility. So those things are possible, but I think the heart of your question was, how do you get that information? You know, it's going to be internal to that government, and that is going to be an extremely difficult thing to pry loose. And again, it's going to depend maybe somewhat on the venue. Does that venue have some ability to get that information? If not, then it may not be possible to criminally prosecute. The second bucket, though, would be to talk about this in terms of state responsibility. It's not an issue of criminally going after an individual, but is a particular state responsible for a wrongful act? And there, I think the standards are not as high as you might find in a criminal proceeding, and that it may be able to prove that a state has committed a wrongful act by virtue simply of knowing what's happened. You know that particular forces were in particular places or did particular bombings or whatever, and you just connect those dots. And it's not critical that you're fingering a particular individual. It's enough to connect it into an organ or agents of a particular state. The third bucket, though, is what I think I was talking a bit about, was that it might be a scenario where you're not trying to criminally tag an individual. You're not even trying to point the finger at a particular government. You're instead trying to simply bring together a large amount of resources for the purpose of post-conflict reconstruction. And that doesn't even have to be targeted to individuals. I sort of pitched it as maybe everybody gets X amount of money. It could be more collective in nature. It could be, we're going to rebuild this town or this medical facility or whatnot, such that it's not an individual who's benefiting, but the society as a whole. On the second question, I think the best precedents to look at are both with respect to Libya and Iraq, where you have NGOs stepping up to gather up information and store it in a database, and then separately, in due course, a willingness on the part of the United Nations to convene a formal body that would, in fact, take this information into custody, organize it. For what purpose? In due course, it could be bucket number one, criminal liability. It could be bucket number two, state responsibility. It could be something else entirely. But there is a way to do that. I think the question would be, can you politically within the UN system do that, given the various actors involved in this particular conflict? Because in some respects, Libya, Iraq would be examples of very isolated states that you could get political will to do this, and maybe that's not the case here.
Okay, regarding the question about the people's point of view regarding the difference between 2014 and now, I think now the people in Yemen have been in a very bad situation. The talking or the daily talk in the street you can hear is about the basic services, about electricity, about water, medicine, paying salaries. So I think it's important, or the priority for the moment is to end the war, and in any coming political process or agreement, the accountability should be there, because the failure of the transition in Yemen 2014 was not a coincidence. It was first by the immunity and the protection to the former president, Saleh, and then the failure to implement the 20 points before the National Dialogue Conference, which was suggested by the technical committee. And in these 20 points, there were some points regarding addressing grievances of abuses in the south, in Saada wars, etc., which would help to an extent to prepare the political atmosphere for the National Dialogue Conference. And it didn't happen. And people rushed to the National Dialogue Conference, and then it failed in 2014, and we entered in this cycle of armed conflict.
Well, before we have our closing remarks, I want to thank the speakers. Thanks for great discussion. Thank you.
Welcome.
So to finish, we're going to have some closing remarks from Daniela Tejada Venegas. She is the wife of Matthew Hedges, and as you know, mounted a campaign to free her husband while he was detained, and is now using that experience to campaign for other people that are also being arbitrarily detained. So with that, I'd like to welcome her up here. Okay.
First of all, I want to thank all of you for joining us today at this conference, which I hope has provided a lot of insights, valuable insights, and kind of room for thought for all of us to leave with something, at least a small point of action to contribute towards the resolution of the conflict in Yemen, but also the defense of victims of arbitrary imprisonment and of torture and just basically violations of human rights and due legal process. It has been an honor to take part in this exercise of debate and analysis that will hopefully result in bettering mutual understanding and the eventual improvement of human rights in the UAE, its neighboring countries, and its Western allies. Today's panels looked at human rights situation in the UAE and the Arabian Peninsula. We also talked about Yemen and how the UAE's domestic policies have an incidence in their actions abroad. The UAE boasts impressive infrastructure and remarkable growth in less than 50 years since its establishment. Its leaders have been strong verbal advocates for welcoming globalization into the country in the form of cultural and educational exchanges and establishing themselves as pioneers in the Middle East region in this regard. However, in practice, and in spite of its powerful media apparatus, the UAE's increasingly restrictive laws are showing the world a very dark side to this wealthy Arab nation. Freedom of thought and expression are suppressed through vague laws and the conveniently arbitrary interpretation of the same. Those with differing or simply independent views of the state face the risk of seeing their rights to freedom, dignified, humane treatment, and due legal process being violated. Today's panel showed us that in less than subtle manners, local and Western scholars alike are subject to intimidation, facing harassment, and in the worst yet not uncommon scenario, detention by the country's increasingly powerful state security bodies. There is a worrying trend of deterring handling of legal cases and substandard treatment of prisoners and detainees in the UAE, and very problematically also abroad. We have on one hand the case of my husband Matthew, who was detained in solitary confinement for 6 months, denied legal, consular, and independent medical counsel. He was arbitrarily handed a life in prison sentence over false espionage charges later. And after that, he was nearly cynically given a presidential pardon. On the more vulnerable spectrum, though, we have academic and economist and human rights defender Dr. Nasser Bengaith, who's been sentenced to 10 years in prison in 2017 under the country's extremely vague cybercrime and counterterrorism laws. There's also human rights activist Ahmed Mansour, whose 10-year sentence was upheld by the UAE court on December 31st, 2018, just as we were all celebrating the New Year's coming. There's also Dr. Mohammed Al-Rokan. He's a defense lawyer who also represented Emirati political opposition figures, including Dr. Bengaith and Mr. Mansour themselves. That goes without saying that there are numerous prisoners in the UAE-run jails in Yemen whose fundamental rights are violated on a daily basis. I hope that from today's panels, we can really look into Western governments and institutions who in their silence have become accomplices of the UAE's deliberate mishandling of legal cases and arbitrary decision-making. Last year, I led a strong media campaign, which I believe resulted in my husband's release. However, I can't help but wonder what could have happened to him had I not counted with the adequate preparation to advocate for his innocence and release, or simply the right help. Would his government have defended him with as much determination? Nearly 5 months of silence from their side prior to my media campaign seemed to indicate that they wouldn't have. As such, in order to hold the UAE and other authoritarian regimes accountable for their violations of human rights and international law, both domestically and abroad, it is imperative to first publicly inquire into and question our own leaders and organizations' compliance to authoritarian regimes' disregard for due legal process and human dignity. I believe, not just from my personal experience, but maybe because I'm a dreamer, that collectively we do have the power to pressure and shape relationships between East and West, be drivers of mutual understanding, and stand up for those who are not able to defend themselves. Thank you.
Well, I'd like to close the program just by thanking everyone who has participated, including our last speaker. It's hard to imagine a more powerful expression of the value of the rule of law and how it can be deployed together with political pressure and other things to make a difference for both individuals and societies. So I hope this has been a useful and worthwhile program for you. We intend at the Society to continue to highlight these kinds of issues through our signature initiatives and in other ways. We will be addressing some of these issues at our annual meeting in, I think, about 9 weeks from now here in Washington. I encourage those of you who have a broader interest in international law and rule of law issues to consider attending that event. With that, I want to thank our panelists, again to thank Ide for all of her work in putting this program together. Thank you all for being here, and we are adjourned.